Start para. The state has filed the present appeal impugning the order passed by the High Court, whereby the petition filed by the respondent number 1 seeking quashing of the FIR was allowed, and the same was quashed on the basis of the compromise entered into between the complainant and the accused. Briefly stated, the facts available on record are that a complaint was filed by the respondent number 2 with the police alleging certain offences committed by the respondent number 1, on the basis of which FIR in question was registered. Respondent number 1 at the relevant point of time was working as veterinary doctor in Sonipat Animal Husbandry Department. Para. Immediately after registration of the FIR, while the matter was still under investigation, the respondent number 1 filed a petition in the High Court seeking quashing thereof. A perusal of the impugned order passed by the High Court shows that the accused as well as the complainant submitted before the High Court that the matter in dispute has been amicably settled between the parties, hence, the FIR may be quashed on the basis of the compromise. Para. Even though in the reply filed by the state to the quashing petition, the stand taken was that the FIR does not deserve to be quashed, as there are serious allegations against the respondent number 1. However, the High Court quashed the FIR merely because the complainant had compromised the matter with the accused. The aforesaid order is impugned by the state before this court. Para. Learned counsel for the appellant submitted that once, on the basis of a complaint submitted to the police, an FIR had been registered with the allegations that the respondent number 1 was involved in commission of serious offences during her service career, and the matter was still under investigation, the High Court exceeded its jurisdiction in quashing the FIR, merely because the complainant had compromised the matter with the accused. After the FIR was registered, or even before that, it was not the complainant only who was the sufferer, rather it was an offence against the state. The allegation against the respondent number 1 was of defrauding the state, her employer. The FIR was registered as cognizable offence was found to have been committed by the respondent number 1. The stand taken by the state before the High Court was not even considered. Para. On the other hand, learned counsel for the respondent number 1 submitted that the complainant had no locus to involve in the issue. He had filed a complaint to the police with certain allegations with regard to her service career, referring to certain documents, which were not privy to him. Registration of FIR against respondent number 1 was merely to harass her, who had otherwise exposed various irregularities in the Animal Husbandry Department. Even in the departmental proceedings, the respondent number 1 has been exonerated after due inquiry. If FIR is allowed to be proceeded with, it will be nothing else but an abuse of process of law. The High Court has not committed any error in the exercise of jurisdiction to quash the FIR. We have heard learned counsel for the parties and perused the paper book. In the case in hand, on the basis of information received under the right 2 Information Act, 2015. The respondent number 2 filed complaint to the police, on the basis of which FIR in question was registered. Stop.